Thank you. I'm Christopher Friez, as you said, with the Crowley Fleck firm here in Bismarck. I have been practicing in the area of oil and gas and energy for going on 8 years, I guess, now. Glad to be here. I want to thank the UND Law Review for putting this on and for having us. Great crowd and great program, I think. So we'll go ahead and get started. I was talking about this presentation with my wife, and my soon-to-be 8-year-old son overheard us, and he said, "Well, Dad, what are you going to be talking about? What are you going to be discussing with these people?" And I said, "Well, I'm going to be telling them about title issues, mineral title issues." And he said, "What do you mean?" And I said, "Well, you know, what I do every day at work, my practice, and as a lawyer." And he said, "Oh, you mean those really boring papers that you're looking at all the time and flipping through?" And I said, "Yeah, that's pretty much it." And he said, "Well, Dad, that's going to be really boring. I don't think you want to talk about that. They're not going to want to hear you." So unfortunately, I'm going to bore you, and we're going to talk about what Brian and I have identified as some common issues in preparing title opinions in North Dakota. So I'm sorry to bore you, but that's just how it's going to be. I'm going to talk about these first 4. We've identified 8 common issues that we see in preparing title opinions. The 8 are up there on the PowerPoint. Brian's going to talk about the second 4. I'm going to take those first 4. So we'll go ahead and get started right away with title standards, which I think my son is right. This probably is pretty boring. Title standards are pretty dry. I remember when I first started practicing in this area, the first day I got there, one of the lawyers who had been doing this for a long time said, "Here's the title standards, read these, understand them, know them, and then you can start working." And so I'm going through reading these thinking, "Oh, wow, yeah, this is going to be fun." So title standards are basically standards and criteria that groups of lawyers who practice in the area of property get together and adopt. Standards that we will apply to conveyances and to warranty deeds, things like that, so that we can be on common ground in interpreting documents. So it's generally the consensus of a majority of the lawyers that practice in that area, and it's accepted as a standard, so that if you're operating under those standards and you have a given set of facts in a conveyance, if you apply those title standards, you're operating under the proper standard of care for that conveyance. So they just give you some guidance to rely on and to use as you're going forward and as you're going through these title issues. It should be noted that they don't have the force of law. They're typically not adopted or enacted into law. There's only one state that I'm aware of in the country that actually has codified and adopted their title standards, and that's South Dakota. Their title standards are right in their statutory code. They're the only one I know about that does that. I think there's some issues with that. I mean, it's good because it then does have the force of law, but also just amending them seems to be a lot more difficult. You can only amend them when the legislature's meeting, and in states like North Dakota, South Dakota, where the legislature only meets every couple years, if you have an issue that you need to amend, it's going to be difficult to do that. Even though they don't have the force of law, courts do rely on title standards when they're interpreting conveyances. So they give them a lot of faith in these title standards, and they rely on them. And they say, okay, here's how the conveyance would be interpreted under the title standard. We're going to use that in our judicial determination of how the conveyance is interpreted. So if you're an attorney practicing in the area, you want to make sure that you're looking at conveyances in accordance with the title standards, because that's probably what the court's going to ultimately find. Most states, especially states that don't have a lot of mineral production, exploration, they're just related to general property law. Title standards apply to property in terms of regular real estate conveyances, commercial property, residential property. Most states don't have mineral-specific title standards. Some states do address minerals within their regular title standards, so they've got a mineral section, like North Dakota does. We've got our regular North Dakota title standards. Within those title standards, there is a mineral section. It's fairly short, but it's there. North Dakota is one of the few states that I know about that actually has separate mineral title standards. So we've got our regular real property title standards, and then we've got a separate volume of mineral title standards that were developed several decades ago by some attorneys that were practicing in that area. And they're very detailed. They have a lot of good information. They cite case law, they cite statutes, they cite various things where they derived their standards from. So if you're practicing in mineral title and you're doing title opinions, looking at conveyances, very good reference, very good resource to use and to be aware of. So as I said earlier, the title standards themselves provide guidance to questions and issues that you encounter as you're going through and examining title. They give you some guidance as to how a conveyance should be interpreted and how other lawyers would interpret it based on applying those title standards. If you're going to practice in a jurisdiction that has title standards, specifically mineral ones, you want to be aware of them. You got to be familiar with those title standards, know what they say, and how you should operate under them. Also, like I said, under the mineral title standards in North Dakota, they cite a lot of case law. They cite a lot of statutes in terms of here's where we derived this title standard from. It's always good to go and look at those cases and those statutes so that you can see why that title standard says what it does, how it was developed, and what it actually means. And sometimes when you go look at the cases or the statutes, you're going to find things that aren't necessarily mentioned in the title standard itself that will help you in interpreting your conveyance. So something to be aware of, something to know about, specifically if you're practicing in North Dakota and you're doing North Dakota title, you want to make sure that you're reading those title standards, that you have a copy, and that you're referring to them when you need to. So with that, moving into Affidavit of Production statutes. This is kind of an interesting area. It's basically the situation where you have an oil and gas lease of record. That oil and gas lease has a definite term. It says it's for 5 years, for 3 years, whatever it might be. What happens when you're past that 5-year term and you've got nothing of record that releases that lease or says it's no good anymore? So you've got your lease of record. It appears that it's expired because it's a 5-year term and now 15 years have passed, but there's nothing of record that indicates whether it is or it hasn't been released or whether it is expired. So what an affidavit of production statute does is helps you determine, whether that lease is expired, whether it's still good, whether you can go take a new lease, and what lease will apply to that mineral interest. So in the normal course, you've got the lease, you've got the primary term for the number of years, but then you've also got a potential for a secondary term where that lease can be held beyond that 5-year primary term by production or an extension or something. When you're looking at title and you're looking at that lease and you see it of record, that extension into that secondary term is often dependent on facts that you might not have of record. You might not have anything of record that says there was a well drilled and there's production on those lands covered by that lease. You might not have a record that there was an extension of the lease in some other fashion. So that's where these affidavit of production statutes come into play. In the title exam arena, there's typically 3 ways states deal with this issue of how do we know if a lease is extended or expired or released. One of the ways is the first one up there, affidavits of non-production or non-development, where an individual or a governmental entity in charge of regulating oil and gas and production puts something of record that says there has been no production on the lands covered by this lease or any lands pooled with lands covered by that lease in a certain time frame, and that gives you the presumption that that lease is expired because it's not held by anything and there's no production on the land. So you can move forward with the presumption that the primary term is over, the lease is expired, you can take a new lease, and your new lease will be valid. The second way is where the mineral owner themselves can record an affidavit saying that this lease is terminated or it's been forfeited and it's no longer valid, and there can be a new lease taken on this property. Some states have a really formal procedure where the mineral owner can go through this formal procedure to show that the lease is expired or forfeited, terminated, and then once that procedure is completed, the lease is deemed terminated. There's no more presumption, it's just fact. It's no longer any good. North Dakota doesn't have that. I don't know which states particularly do, but that's one of the ways of dealing with this. The third way is what I want to talk about most is the affidavit of production itself, and this is one of the ways North Dakota deals with this issue, and we have it in our statutes. This says that the lease basically is presumed to be expired unless there's evidence of record that that lease is continued into its secondary term for some reason. So if you don't have an affidavit of production on the lands covered by the lease, once you're beyond that primary term, you can maybe make that presumption that the lease is expired because there's nothing of record that shows it's producing. Now, that doesn't mean that if you have notice of production or some other way that that lease is held, that you're going to be okay. But barring any actual notice or inquiry notice or going out and doing a surface inspection and not seeing a well on that property, you can make that presumption that if that lease has a 5-year term and you're beyond that term and there's no affidavit of production or any other evidence of record that shows the lease is continued, the lease is no longer valid, and you can take a new lease. As long as you don't have that other notice, you're going to be fine and your lease is going to be valid. So if you're the owner of the lease, if you're the lessee and you've got this lease that is beyond its primary term, the way to protect yourself is to file the affidavit of production. So you record an affidavit in the county records describing the lease and saying that we drilled a well and there's production on these lands covered by this lease. So our lease is now held by production beyond its primary term. It's not expired. Nobody can go out and take a new lease because our lease is still valid and it's good and it's continued. If the lessee fails to record that notice, even though there might be production there, you don't give notice to those third parties. If they don't have any other kind of notice, they could knock you out as a bona fide purchaser and take a new lease and beat you to it. And your lease might not be held valid because you didn't put anything of record. So you've got to make sure that you've got that notice of record by way of the affidavit of production so that people know that your lease is still valid and that it's held beyond that production. There are at least 6 states that I know that have these statutes that basically require you to record this affidavit to protect your lease. And if you don't record that affidavit, you run that risk of losing your lease because a third party that doesn't have notice could come in and take a new lease and knock your lease out. Now, there is some interesting case law that I've run across, and I believe it's out of Kansas or Nebraska. I think it's Kansas, but it sort of goes. It takes this affidavit of production statute really far, and it says, let's say that you have a working interest in the lease, and I have an override in the lease, and you as the working interest owner record your affidavit of production to show that the lease is held beyond the primary term, but I as the overriding royalty owner don't do that. There's a situation where I didn't protect my interest. The court in Kansas has actually held that because I didn't take the step, even though the operator did, that doesn't protect me. It only protects the operator. So it's a little bit scary in terms of where courts could go with this. We haven't had anything like that in North Dakota, and I don't think that's clearly not the majority rule by any means, so it's nothing to be too afraid of. But it's out there, and it's interesting because they say, look, if you've got an interest in a lease, you yourself need to protect that interest, and you can't rely on others to do that for you. So it's an interesting situation, and just to know that if you're out there and you've got these leases, you've got to take it upon yourself to protect yourself and make sure that everything is taken care of. So from a title examiner perspective, what do we need to know about affidavits of production and what good is all this? If you're preparing title opinions in states that have the affidavit of production statutes, you probably want to put in your title opinion that, once you establish production, you want to get an affidavit of record establishing that your production is there and maintaining your leases. And you want to tell your operator client that they should do that so that they go ahead and get that in the county records and make sure their leases are protected. Moving into one of the more complex title issues, I guess, that we see, something that's been around for a long time, started in Texas and has made its way through the rest of the country, the Duhigg Rule, which is one of those things it's complex and it's hard to understand, but it's important because it can have big implications on conveyances and reservations and who owns the minerals under certain tracts of land. In 1971, as it says, North Dakota adopted the general Duhigg Rule, which was first adopted by the court in Texas. And the typical situation is A owns the surface and half the minerals in a tract. A conveys the land to B and reserves a 1/2 mineral interest. Under that conveyance, the Duhigg construction of that conveyance says A purports to convey a 1/2 mineral interest and to reserve a 1/2 mineral interest. Because A only has 1/2 of the minerals, it cannot fulfill both the conveyance of 1/2 and the reservation of 1/2. So we've got a problem. The Duhigg Rule says we're going to focus on what the grantor purports to convey to the grantee and not on what they reserve. So because they conveyed 100%, reserving half, that looks like they conveyed a half as well, and the grantee is going to get that 1/2 mineral interest, and the grantor is going to be out. They no longer own the minerals, even though it looks like they probably intended to reserve what they had. But that's the construction of Duhigg. It says that somebody has to win and somebody has to lose, and we're going to take this line, and this is how it's going to be. In North Dakota, we've taken the Duhigg Rule, and the court has modified it somewhat under certain fact situations, extended it a little bit under other fact situations, and said it doesn't apply to some. In 1999, in this Miller versus Kleckner case, the North Dakota Supreme Court said a warranty is not necessarily required in a conveyance to apply Duhigg to that conveyance. So you could have a quitclaim deed with no warranty in it, and we're going to still apply Duhigg, even though some would argue that the warranty is what gets you to Duhigg. The North Dakota Supreme Court said no, it can apply in any situation, and the warranty doesn't need to be there. So if you have a limited warranty or no warranty, we're going to still apply the Duhigg construction, and that grantor is going to lose those minerals. In another case, this Gilbertson versus Charleston case that can really trip you up as a title examiner or as a landman or whoever you are looking at these conveyances, because the court here takes a pretty narrow view and makes a real narrow a real narrow distinction of Duhigg. It says, you know, we apply the Duhigg rule in the normal case. However, if the grantor and the grantee are co-tenants in the property, in other words, if they both own interests in the property prior to that conveyance, we're not going to apply Duhigg. So in the first example, if A owns the surface and half the minerals, and B owns the other half of the minerals, or any part of the minerals, and A conveys to B, reserving a 1/2 mineral interest, B is a co-tenant with A, so we're not going to apply Duhigg, and A is going to keep his 1/2 mineral interest. So you got to watch out for that in title if you're going through and you've got a co-tenant situation. The normal case where you think, okay, this is classic Duhigg, it applies here. If you've got co-tenants, it doesn't. So it can really change title, and you've got to be aware of that. Just one of those exceptions that the court has made for us. The premise behind Duhigg, and the reason I think that the rule is adopted the way it is just to say that, you know, the burden is basically on the grantor to say what they mean and to get it right. And the risk of title is on them. So if they say it wrong, they're going to lose. So if we've got this competing interest where we've got 50% of the minerals out there that are in question, the grantor is going to lose because they're the ones that have the risk of title. So if both the grant and the reservation can't be given effect because we don't have enough mineral interest to do that, the grantor is going to lose and the grantee is going to win. And the court just had to pick a side and say, we've got to interpret these somehow, so here's how we're going to do it. Now everybody's on notice. This is what's going to apply going forward, and that's just how it is. So if the grantor doesn't own enough minerals to satisfy both the grant and the reservation in the deed, the grant has to be satisfied first. So the grantee is going to get what they are supposed to acquire, and we're going to take whatever's left out of the grantor's interest. So they might not get anything if there's not enough to fulfill both. The focus in a Duhigg interpretation is not what the grantor purported to retain, but what they purported to give to the grantee. So that's what you've got to be looking at when you're interpreting these types of conveyances. One of the reasons I wanted to talk about Duhigg today, because it is a classic title issue, but we've had 3 Supreme Court cases last fall in North Dakota that came out with new Duhigg interpretations, not necessarily changing anything, but mostly saying what we've done in the past is what we're going to continue to do and keeping those holdings going forward. We've got the first one, the Waldock versus Amber Harvest Corporation. Basically, the grantor, William Edwardson, owned 100% of the surface and 50% of the minerals. He was deceased. The personal representative of his estate wanted to sell the minerals, and so the property, the surface, he went to the court, obtained an order authorizing him to sell the property to the grantee. So once he got that order, he executed a deed, used the language that the personal representative of the estate wanted to grant, bargain, sell, and convey unto the grantee all the right, title, and interest of the said named decedent at the time of his death into the lands, and then the personal representative put this reservation in. He said, accepting and reserving unto the estate, its successors and assigned 25% of the interest in the oil and gas. So it looks like here we've got a Duhigg situation. We've got 100% of the surface and 50% of the minerals being owned by the grantor. We've got a conveyance that conveys everything and reserves 25%. So it looks like we're purporting to convey 75% of the minerals, but we don't have that much. So it looks like the grantee is probably going to win and get everything. But the court here said Duhigg doesn't apply to this case. The court held that the grantee gets their 25% mineral interest and the grantor gets its 25% mineral interest, just like the conveyance says. The reason the court said this is they said the plain language of the deed in the granting clause grants only the right, title, and interest that the decedent had at the time of his death. There's no overconveyance here. He didn't purport to convey more than he had. He didn't purport to convey 75% of the minerals. He only said, I'm conveying whatever I have. So he had 50% of the minerals. He reserved 25. The court said he's still got 25 left. He can fulfill both the grant and the conveyance. So Duhigg doesn't apply to that case. So what I get from this holding is it's very important to look at the language of the deed, to look at the granting clause, to look at the reservation. Duhigg may or may not apply depending on the language used. The second case is this Nichols case, where we had 9 siblings who collectively owned 100% of the surface and 50% of the oil and gas in the tract. Each sibling owned a 1/9 surface interest and a 1/18 interest in the oil and gas. So 8 of the siblings get together separately, separate deeds, and they execute these deeds to sibling number 9. So each of the 8 siblings executes a deed that says, I grant, bargain, sell, and convey all of my undivided 1/9 interest in the tract to sibling number 9. And then they say, we accept 25% of all minerals, oil and gas, and 25% of the royalties. Now, keep in mind that these are separate conveyances. They don't do it together. They each do 8 separate deeds, conveying a 1/9 interest and reserving 25%. So the successors to sibling number 9, who got all of the property, said each of the deeds only reserved 1/4 of the grantor's 1/18 mineral interest, so 25% of whatever the grantor had. So that means we, as successors to sibling 9, get 7/18 of the minerals, and the grantors retain 2/18. So we get most of the minerals. They get 25% of what they had, and we get the rest. Of course, the 8 siblings, the successors to those people, had a problem with that. They said, look, we each executed separate deeds, but this is all part of one transaction. They should be read as one deed. And in that one deed that we should read together, we reserved 1/4 of the total minerals. So whatever we had, we got 1/4 of it, and we get 1/4 of the 50% that we own, not 1/4 of what we each owned. So 2 competing arguments there. The court looked at it and said, the deeds are not ambiguous, so we don't even need to get to Duhigg necessarily. And there's another reason why they don't get to Duhigg that I'll talk about in a second. But the court also said, importantly, that we're not going to read these 8 deeds together as one single transaction. We know that, yeah, it looks like they were a part of the same transaction, but they don't refer to each other. You can't look at one deed and know that there's another deed out there unless you go to the county records and you have all the deeds in front of you. They don't indicate that they're part of the same transaction. There's nothing out there to show us that they are. There's no contract or anything else that indicates they're part of one transaction. So we're going to read them each separately. We're going to interpret them as separate conveyances, and that's the course we're going to take. So with that interpretation, the court said, the deeds are clear. Each deed conveys each of the grantors 1/9 interest in the land and reserves a 1/4 mineral interest. So they say each grantor only owned a 1/18 mineral interest, and so they can't reserve 25%. That would be it would be an overconveyance. They didn't have enough to fulfill that. So you've got Duhigg because there's a problem. They don't have enough to fulfill what they said they were going to fulfill. But the court says, we've got this Gilbertson case, and Duhigg doesn't apply to co-tenants. So these guys are all co-tenants because they all own the property together. So Duhigg doesn't apply. Because they were separate deeds, Gilbertson doesn't apply to collectively reserve 1/4 of the mineral interest in the grantors. So the court says Gilbertson applies, but at the same time, it only applies to each individual deed. So they can only reserve basically what they know about. So each deed reserves 1/4 of each grantor's 1/18 mineral interest. The grantors collectively reserve that 1/9 or 2/18 mineral interest, and the rest goes to sibling number 9. So it's kind of an interesting interplay between Duhigg, Gilbertson, whether you can read all these deeds together or not. Gives us an interesting result, and gets to the result that, you know, the 8 siblings only reserve 1/4 of what they had because they were co-tenants. They knew what was out there. They knew what the state of title was, and we're going to read the deed separately, and they get what they know about. So from these first two cases, what do we need to know as attorneys and landmen and others who are looking at these issues and dealing with them every day? Like I said earlier, the first case, the Waldock deed, the granting clause, the court said, takes the case out of Duhigg. Duhigg doesn't apply because the granting clause only conveys what the grantor had. So he didn't purport to convey any more or any less, just what he had. So it's very important. The language of the granting clause, the reservation, and the document as a whole is extremely important to determine whether Duhigg is going to apply, whether it's not going to apply, whether we're going to have a Gilbertson situation, whatever it might be. We've got to look very, very carefully at the exact language of the document moving forward. The last case that the court came out with under the Duhigg interpretation is just kind of an affirmation of a previous case that was in front of the court some time ago. In 1991, we had this Acoma Oil Corp versus Wilson case where it's a situation where we have an outstanding royalty interest. So somebody owns the minerals. We've got a royalty interest out there burdening the mineral interest, and there's a conveyance. The court in that Acoma case said, when we've got that situation, and the question is, who bears that outstanding royalty? Is it the grantor still, or is it the grantee, or is it both? And how do we make a rule that says who bears that outstanding royalty? Because you've got a problem if the grantor owns the minerals, he bears that outstanding royalty, and then he conveys the minerals. He may not have enough to continue to bear that entire royalty interest. So who's going to bear it, and how do we figure that out? The court in this Acoma case in 1991 said the grant must be satisfied first. So if the grantee owns the minerals and it has to bear this outstanding royalty interest, if the grantor has enough mineral interest left to fulfill that outstanding royalty interest after the conveyance, the grantor is going to continue to bear that outstanding royalty interest, unless the conveyance says that they're going to share in bearing that burden. So the Acoma case also says that if the grantor does not own enough mineral interest after that conveyance to bear that full outstanding royalty interest, then the grantee is going to have to share its proportionate share of that burden. So it's going to be shared between the two. In this Wanko case simply reaffirms North Dakota Supreme Court's application of Duhigg to this situation where there's outstanding royalty. The interesting thing about Acoma is it's been put into the North Dakota Mineral Title Standards. The title standard itself is up on the screen. Basically says if the mineral owner who owns the mineral interest, subject to an outstanding royalty interest, executes a mineral deed that has a warranty clause to a party conveying those any number of mineral acres, if it doesn't reference the outstanding royalty interest, the grantor continues to bear that outstanding royalty, the total of that outstanding royalty, if they retain enough minerals to bear it. So the mineral title standard comes directly from the Acoma case. The last case, this Wanko case, simply reaffirms that this title standard is still how we're going to operate going forward, and we've got good law to go on, and that's how it's going to be. So it's a good case. It's good to see when the court itself reaffirms things that it's done in the past. We've operated under that standard for quite some time. We can continue to operate under that standard. There are no surprises, and we know what the law is. The last topic I want to talk about is an interesting one. Mineral reservations to third parties, the Malloy case, a pretty infamous case in North Dakota as people that are dealing with oil and gas and mineral interests. In 1962, the North Dakota Supreme Court adopted what was the general rule at the time that said you cannot reserve a mineral interest to a third party. It's void. If you've got a third party stranger and you have a conveyance, if A owns all of the minerals and A conveys to B, reserving to C a mineral interest, that reservation to C is invalid. It's no good. You can't do it. So that's the standard that we're operating under in North Dakota, that you can't reserve an interest to a third party. So in 1983, along comes this Malloy case from the Supreme Court where the court modifies this rule a little bit and says, yeah, we've got that Stetson case out there, no third-party reservations, but in Malloy, the court says a reservation can be effective to convey a property interest to a spouse who might be an otherwise third-party stranger if they don't own an interest in the land prior to the deed. But if that spouse joins in the execution of the deed and it looks like it was the grantor's intent to reserve that interest to the spouse, that reservation is valid, or it can be valid. So the court essentially says that the spouse is not a stranger and may acquire an interest through a reservation. So it modifies the Stetson decision a little bit, especially in terms of where there's a spouse. This poses a real problem because you've got a lot of lawyers who are out there drafting conveyances for a long time operating under the Stetson rule that you can't reserve an interest to a third party stranger, which would include a spouse under Stetson. You've got that rule out there. You've also got the homestead issue where if you're conveying a surface interest, your spouse has to join in that conveyance. Otherwise, the conveyance is potentially void under North Dakota's homestead law. So you've got all these conveyances out there where either the husband or the wife owns the surface and the minerals, and then they go and convey that surface to somebody, and they want to reserve some of the minerals. Both spouses join in the conveyance for homestead purposes, and suddenly you've got a potential third-party reservation to the spouse that didn't own an interest prior to the deed. The problem is most of these conveyances are 50, 60, or more years old, and they were operating under a different rule. So Malloy comes along and modifies all these conveyances that are out there, and from a title perspective, now we don't know who owns the minerals. We think, okay, both the spouses own them now, but the parties themselves didn't operate that way. So if the husband owned the surface and the minerals prior to that deed, they probably never did anything with the wife's estate because they thought the husband owned everything. So maybe they probated the husband's estate and went on down the line, but now we've got potentially half of that mineral interest stuck in that spouse's estate. And it makes it difficult because it's hard to determine intent because the people are probably deceased, and nobody really knows what their intent was unless you can determine it from the face of the document. So it makes it difficult to cure from a title standpoint. How do you cure it? How do you get rid of it? You've got this presumably deceased spouse out there who may or may not own half of the mineral interest. Really the only way to cure that is to probate that deceased spouse's estate and get that interest to where it needs to go. Get a disclaimer from the estate saying, no, that spouse never intended to own any of the interest. Get a deed from the spouse's estate, giving it to the right people. Get a stipulation if you can. If the parties are still alive, you could get a stipulation or a disclaimer to clear it up, but more often than not, the parties are not alive anymore. So the other potential problem it poses is even if you do go through and you probate, what if the spouses had different heirs for some reason? What if the wife decided that she was going to leave everything to the church or whatever it might be? Now all of a sudden you've got half of the minerals out there that you might not have accounted for. They might not be leased, and you've got competing interests. And so it just creates a big, big problem. As title examiners and landmen, others looking at these issues, what do we need to be aware of with Malloy? We've got to know what's out there. We've got to be on the lookout for it, and we've got to flag it anytime we see it. It has a huge impact on title, and we've got to be aware of that and make sure that we know what that impact might be. Very interesting thing happened last week. It was last week, right? The Supreme Court, that was last week, right? Was it the week before? A couple weeks ago. The weeks are all running together. Anyway, there was a Supreme Court argument just a couple weeks ago here in North Dakota talking about this specific issue. There was a conveyance in there. One grantor owned 2/3 of the minerals. One grantor owned 1/3 of the minerals. Both grantors got together with their spouses, conveyed the property, and reserved the minerals to the grantor. So we've got 2/3 and 1/3, and then we've got spouses. So now the question becomes, does the grantor that owned 2/3 retain his 2/3, or does everybody get a 1/4? And does that guy that had 2/3 now lose part of his minerals because of Malloy? What's the potential impact? The argument was really fun to listen to. It was interesting to hear the justices discuss Malloy. I'm really excited for the opinion to come out to see what we're going to do going forward. How is Malloy going to be impacted? Are they going to change it? Are they going to modify it? Is it going to stay the same? So something to watch out for. It'll be interesting to see. I'm sure it'll be a few months before we have anything from the court, but very interesting thing to be looking for. And I guess when I'm very excited to hear this Malloy case come out, that's like the most exciting thing that's coming out in the next couple months. So anyway, I'll leave you with that. Hopefully I didn't bore you too much. I will turn it over now to Brian. He's gonna talk about the remainder of the common title issues that we've got identified.